Good afternoon, good morning, everyone. My name is Penny Hayes, and I am the CEO of the Trust Bridge. I'm here today in the next of our series of webinars, together with a panel of Malcolm Dowden, Katie Hyman, and David Clark. We're going to be talking about the EU and US data privacy framework today. So before we start, could I ask Malcolm to introduce yourself?
Very good afternoon, everyone. My name is Malcolm Dowden. I'm a data privacy lawyer, co-head of knowledge management at Squire Patton Boggs, which is a law firm that operates on both sides of the Atlantic. We've had quite a lot of discussion over the last couple of weeks about how the data privacy framework should work and whether it is a data privacy or a data privacy framework. The jury is out on the last question.
Thanks, Malcolm. And Katie, welcome. This is your first time on our panel, but we're delighted to have you. Please tell us a little bit about yourself. You're slightly unusual being a British lawyer, but based in Washington, DC.
Yes, that's true. I am a British lawyer, a US lawyer, and I'm based in DC. I'm a partner at Womble Bond Dickinson in their privacy practice. And yes, we've also debated the privacy issue, Malcolm, and with no resolution, and have more concretely been discussing the data privacy framework with our clients.
Great. And David, please introduce yourself as well.
Hi, David Clark, CTO of the Trust Bridge. Previous roles have included being responsible for security for FTSE 500 companies globally.
Lovely. So the subject today, on the 10th of July, so only a couple of weeks ago, the European Commission adopted its adequacy decision after much discussion on the EU and the US data privacy framework. On the basis of this adequacy decision, personal data, strictly speaking, can now flow freely from the EU to organizations in the United States, but those that obviously participate in this framework. This really has come about after the introduction of some safeguards that are being put in place by the US government, which apply to any data transfers under GDPR to organizations in the US. But what exactly were these safeguards? Malcolm, can you explain a little bit about the background to all of this for us?
The background to this really goes back to a series of challenges brought by Austrian privacy campaigner Max Schrems. Firstly, in relation to the safe harbor arrangement that was the first attempt really to arrive at an adequacy framework with the US. Once the safe harbor arrangement had been struck down, it was followed by Privacy Shield, which met a similar fate in the judgment referred to as Schrems 2. And the critical concerns that were expressed and accepted by the European Court of Justice related to very largely US federal government bulk and digital surveillance powers under a range of laws, including FISA 702 and under an executive order 12333 that was really concerned with interception of data in transit for intelligence purposes. And the view that the European Court took was that there were insufficient safeguards and insufficient routes to redress and remedy under the Privacy Shield arrangement. So while Privacy Shield has actually continued to operate over the last couple of years, as far as the DOC is concerned, which is relevant when we come to the transition to DPS, it has not been an adequate transfer mechanism for the purposes of EU GDPR, and it's not been adequate mechanism for the now separate UK GDPR post-Brexit. That's broadly the background. Political discussions have been underway.
That's a good question, actually, with regards to the UK. Do we effectively fit in with this new EU-US data privacy framework? Or is there going to be something else that's a UK-US data privacy framework?
The immediate answer is that the UK is not yet part of this arrangement. There are references, and it's been possible since July the 17th to certify and register on the basis that organizations will take advantage of what's called the UK extension.
Great.
But there needs to be a UK adequacy decision. That's made under Section 17A of Data Protection in 2018. It is subject to a parliamentary procedure called the negative resolution procedure, which means that the arrangement has to be laid before Parliament for the 40 sitting days. If there is no negative resolution within that period, then the adequacy decision becomes law. Problem was, on the 10th of July, we didn't have 40 sitting days this side of the recess. So we're looking maybe November as the earliest practicable date for the UK to join in.
Okay, so let's take a look at what actually is the EU-US data privacy framework. What are the data protection protocols that are now required? What does this framework actually do? Can you explain that to us? Don't mind who, Malcolm or Katie, whichever.
Katie, over to you.
Thanks. I think as Malcolm was alluding to, it's pretty much the same thing as the Privacy Shield, which is relevant because if you already had the Privacy Shield and you didn't withdraw from it, which some companies did because it wasn't adequate anymore, but some companies kept up with it because it's a good way to show that you're complying with some data protection principles. But by and large, those protections are the same. And the reason they're the same is because the problem that the Court of Justice found with the previous mechanisms was not with what the companies were doing. It was with what the government was doing. As Malcolm said, what you're doing as a company is the same as it was before. So if you were compliant with the Privacy Shield, then you're going to be compliant pretty much with the new data privacy framework. And which is to say that things have changed over the last few years. So you would do well to look through your privacy policies and make sure that you're still compliant and that you're doing all the right things. But the actual requirements are the same as they were before.
Malcolm, what's the scope of this then?
I think the really important point is that it is not an adequacy decision in favor of the US. It is not an adequacy decision in favor of any particular US states. It's an adequacy decision that relates to organizations who are data importers, data recipients in the US, who are DPF participants. In other words, they are actually on the list that's maintained by the US Department of Commerce. And I emphasize that on the list because if you're not one of those organizations that was Privacy Shield, self-certified and registered, so you've got immediate transition into the new regime, there is a time lag between self-certification, verification of that organization, and its appearance on the list. And equally, there are ongoing monitoring provisions that could, in certain circumstances, lead to organizations being removed from that list.
How'd you get yourself on the list in the first place? Isn't the question.
Yeah, so in essence, you self-certify, which means that you publicly commit to adhering to the set of principles, core principles and supplemental principles that are set out in the adequacy decision. That really is a promise that you will be handling personal data in a compliant manner. And from self-certification, there is a verification of validation process that essentially checks that you mean what you've said and you're implementing those promises, and organizations are then entered onto the list that's maintained by DOC. And important to emphasize that it's entities that are entered onto the list. Sorry. Thing.
David, I'm going to throw a question while Malcolm's sorting out his microphone. Can I ask you a question then? We've done quite a bit of work with American organizations on the development of the WISC, the written information security protocols. So presumably going through that process is, and then issuing that WI WISP, that's also a sort of commitment to working, should be from now on, working within the EU-US data privacy framework.
It is part of that, making sure technical and organizational measures are in place. And as you say, it's a kind of public declaration of how it works internally in the company,
Okay.
which is always a good thing.
Yeah.
And I think I read today that listed companies now are going to have to report data breaches now throughout
well.
the US as well, which is going to make things a little bit tighter.
Yeah.
Sure.
Yeah, definitely. Sorry, Malcolm, let's come back to you again now. You were talking about it's to do with entities, so explain what you meant by that.
That's right. Is the microphone working now?
It's very quiet.
Okay, let's lean in. Yeah, so what I was saying was that the list of entities that's maintained by the US Department of Commerce is at entity level. So if you're looking at the sort of parent organization in a group, you do need to click through on the list on the DPF site to see whether the particular entity to whom you're transferring data is on the list of covered entities within that self-certification and entry on the list.
That makes sense. Katie, have you had to do much work with clients over the last couple of weeks to do with this, changing them maybe from their standard contractual clauses to anything new and different to make sure that they're aligned with this new framework?
At the moment, because of that time lag, companies still do need to rely on their standard contractual clauses unless they were already in the privacy shield.
Yeah.
But I don't think many of my clients are ready to fully rely on the new mechanism quite yet, because even those who had still maintained, and I think most of my clients actually did not maintain their certification just because they didn't seem worthwhile to them. So most of them had previously been certified, so they will again, but they are going to have to go through that process again. So we're still relying on the standard contractual clauses, and we are making sure we're looking through the language in the amendment in our DPAs to make sure that they cover standard contractual clauses and this mechanism once they're accepted by it.
We're into extra money, presumably, for organizations to start putting resources against all of this again. And I know we've frequently talked about this with clients in terms of the commercial value. Malcolm, I know you have a view on whether or not it's worth it to actually go through the process that you have to go through here. What's your thoughts on that?
Very much a question of whether clients have spent a lot of money already in terms of putting in place standard contractual clauses, transfer risk assessments, and other mechanisms since Schrems 2. And what we're inviting clients to do at the moment is to look at whether the arrangements that they have in place are sufficient for their data transfers, their processing activities, and whether there's likely to be any material change. So whether they're looking to open up new processing activities or to involve other organizations. If they're pretty much holding station, then the standard contractual clauses plus the transfer risk assessment provide them with an appropriate safeguard under Article 46. So I'm certainly not advising organizations to just make a wholesale switch without really thinking of the cost-benefit analysis first. And in the background, we know that we've had Schrems 1 and Schrems 2. The man loves a sequel, so we could well have Schrems 3.
Yeah, that was one of my questions was going to be, do we know what he's planning at the moment for Schrems 3?
It's coming soon to cinemas near you. I think it's almost immediately NOYB, none of your business, the organization with which Max Schrems is associated, issued a fairly scathing criticism of the redress mechanism that is a key part of the adequacy decision. And essentially, making a fairly strong statement that the Data Protection Review Court is not a court, doesn't provide a sufficient degree of transparency, doesn't provide a meaningful avenue of redress. So that element, I think, is where the challenge is most likely to focus.
So what we do in the interim, what happens to us if we start transferring data? Many organizations are already transferring data, perhaps not even necessarily knowing that they're doing it. But what happens at the moment? Are we risking life and limb by continuing as we are at the moment? I'll throw that one at Katie.
It's just been, I think we're where we've been this whole time, which is that it's currently been, this is a new thing. This is now a legal way to do it. It's probably, it may well be the case as with SCREMS 1, 2, and probably soon 3, that it will then be declared that all those transfers are retroactively illegal. But while that hasn't happened, carry on, I guess is what I would say. But as Malcolm said, spending a lot of money on changing everything when we have an idea that this may not stick around. It depends on the companies, because I have companies that are SaaS providers, for example, and for them, it's really important to just be able to say that they are compliant with whatever the certification is, because that's great for their clients. So for some people, it is going to be worth it. And for others, yeah, it probably won't be.
Yeah, I think that's an important point. If you're looking at service providers, there is that kind of marketing reputation or sort of allure to customers. The context I was really talking about there is more the kind of intra-group transfers of data, where the question mark might be a lot more pronounced about whether it's worth taking that step without running that cost analysis.
And David, I mean, we probably advise clients on all sorts of cybersecurity protocols and data protection protocols anyway. So presumably it's best just to have those regardless of any kind of framework. You should really be making sure that everything was protocols in place anyway.
Probably in reality, as Malcolm and I were discussing, it's probably not going to change. We're all going to use the same encryption as we are and manage it. Although you could argue the encryption is still fundamentally controlled by US, although that is changing. A lot of the big providers now are integrating a customer ownership of encryption keys. So absolutely.
Having got so many different privacy laws all over in the different states in the US, how are any of those affected? Do any of those affect this framework? Or is it at a federal level, this new framework that we've got? Malcolm, I'll throw that one at you.
As said, the adequacy decision is in favor of the particular scheme, the particular project. That project is supported by measures at federal government level, so Executive Order 14086 and the Attorney General regulations that go with the data privacy framework. So I suppose the point there is that if we have a DPF participant organization, then transfers to that organization are covered by this adequacy decision. If they're not participant organizations, then, as you mentioned earlier, those federal government measures actually do apply to all transfers of personal data to the US. So I think they do have some sort of more general benefit when it comes to country risk assessment and the content of the transfer risk assessment that you carry out for those non-DPF transfers.
And I'm making an assumption here that it's a two-way street, this EU, US, EU.
There's, from an EU perspective, there's never a problem transferring data into the EU, similarly with the UK. The principle there being that data is coming in to a protective environment.
Yes, of course. So that's providing that people were under the whole GDPR rules and regulations, that they were already in place. So that's fine. So that doesn't really change anything in that situation. Okay.
No, what we're talking about here refers to the US and onward transfers as being affected by the scheme.
Onward transfers within the US or onward transfers out of the US to other jurisdictions?
Either of those, onward transfers within the US to non-DPF participant organizations, or onward transfers by US DPF participants to third countries
Right.
that don't themselves have adequacy decisions.
So practically, what have we got to do and how long have we got to do it in? What I say we, I'm talking about EU organizations transferring to the US.
Katie, do you want to start?
Practically, it's that self-certification process that Malcolm was talking about. And there isn't a time frame because you can just do it when you're ready, and you should do it when you're ready, because if there's things you need to do, then you need to obviously take the time to do them. And the sorts of things that you're going to be certifying are how describing your organization's privacy policies. So of course, before you do describe them to this program, you need to make sure you have them and that they're adequate and they're proper and that they cover all the data you're supposed to be covering. So for some organizations, you're fine, you're ready to go, and it's just a matter of plugging that information into the program's website. But for other people, there might be a more thorough look at their data practices that they need to do.
So it does feel to me very much like the sort of extension of the whole WISP program that's now a legal requirement in many states. Am I missing something?
Really? I think that's true. I think that some of the specific details are going to be possibly slightly different in terms of the focus isn't so much security, which I think is really the focus of WISP, but about security is absolutely one of the features, but just about privacy, things like data retention and stuff like that, which I wouldn't put under the security umbrella necessarily, but things like that are important for this. Yes, it is like WISP, but I think with a slightly broader remit.
Yeah, sure. So is this kind of it now? Do you think this is, I know we don't know what Max Schrems is going to be doing, but do we think this is now the right kind of frameworks in place? Does it need any adjustment going forward?
I have Malcolm look like he had lots to say.
You carry on.
I was just going to say that I when I read the Max Schrems comments on this new policy, I thought it's true what he says, that the problems that were identified were government problems. The changes that have been made are quite minor. One of the changes is that the Court of Justice said that to kind of the use of proportionate in surveillance, and the way they've dealt with that is just by saying that any surveillance will be proportionate, and that's how they've done it. That's just how they fixed that. They've just put the word proportionate in, which I don't know. Is the court going to think that's sufficient? Doesn't sound like it's going to work to me. And then they've sort of caught that they've got Max Schrems has already said it doesn't work and it's not going to work. I don't know how he can say that for sure, since it hasn't worked, hasn't happened yet. So I think we'll see what it does. But if it is the previous versions of this, then it won't be sufficient. And it doesn't seem like it's going to be that one of the fundamental problems is that there isn't an EU person can't contact someone in the US and ask them about their data. They have to go to their own authority, and then that goes to the US. So there isn't a direct line. And it sends the EU says, well, that's because then it's in your own language. So you can speak to someone in your language. Yes, that's probably true. That's helpful. But it's not you're not having a direct kind of dialogue with someone in the US about your data, which I think is probably what people had in mind with this.
Sure.
Yeah, I'm not. I think that since those are the problems and those problems haven't really been addressed, I don't think that it's going to go away.
Yeah. So Malcolm, proportionate, a bit like reasonable. Define.
I'm tempted to say it depends. Yeah, it's absolutely the case that the criticisms that have been leveled at the measures are fairly compelling on the basis that Katie's set out. There's also the concern that's expressed quite often that the structure rests on an executive order, and an executive order is as fragile as the president's sanity and health or change of president. There are legitimate reasons for suspecting that there will be a challenge, and that challenge may be to at least some extent successful in the court. Countervailing point is there is a lot of political capital, a lot of political will behind this, both on the US side and certainly on the part of the EU Commission. would be quite seismic for the European Court to overturn it, but they've done so before.
Yeah.
So I think where that brings us in terms of practicality is that we've certainly been advising clients to, if they're moving towards DPF listing, to at least contemplate keeping standard contractual clauses and transfer risk assessments that they have in place in their back pocket, to be prepared to move on to those appropriate safeguards under Article 46 if the adequacy decision is torpedoed at any point. In the meantime, I mean, there are some things that are easier for organizations who were Privacy Shield certified. So we have until, for example, 10th of October to update privacy notices for those organizations so they can make an immediate transition, focusing on that sort of minimum level of activity that you need as a former Privacy Shield organization to glide into DPF is probably not too costly, but keep the SECs in your back pocket. I think is the punchline.
Good data. That's my birthday. Okay. David, we quite often when we're doing data flows and data maps for clients, point out to them that their data is perhaps inadvertently being transferred because they're using cloud systems. How are they affected in this situation? Do they have to do anything now, or is that all in the hands of the cloud supplier that they're using, or the email supplier that they're using?
I guess probably, as kind of Malcolm was saying earlier and Katie, it depends on how much money you want to spend on it. And it's probably going to be an awful lot of investment to change it. It may be that they, in the way to solve it in the end, and it may not be a complete solution. If the customer in Europe can manage the encryption keys away from kind of the US companies, which is available now, it's potential in some circumstances. It will be an easy transfer.
Yeah.
Because I think it's very hard for any company to argue against US authorities on these issues.
So I think in summary, I'm getting the feeling that there's not an awful lot to do just at the moment, providing that you have signed up to Privacy Shield, but just keep an eye out for what might be changes that might be coming down the line, especially if Max Schrems starts playing ball again. Would that be a suitable summary, would you say, Malcolm?
I think that it's a suitable summary as far as we've got. There's one other question that I think is worth resurfacing in this webinar. There are divided views on this on opposite sides of the Atlantic, and that is if you are making a transfer of personal data to the US, you are the EU data exporter to a non-DPF participant, do you have to still do a transfer risk assessment? And I'd say I'm very firmly on the side that says, yes, you do. The transfer risk assessment is the obligation of the EU data exporter. It includes a country risk assessment element. And I think it's fair to say, and the Department of Commerce and the European Commission have said, that the measures that are applicable to all data transfers should help with that transfer risk assessment. But I'm not sure where that gets us in practice. The reason for carrying out a transfer risk assessment or a transfer impact assessment was to determine whether you could use just the Article 46 appropriate safeguard, so standard contract clauses, binding corporate rules, or whether you needed as well to put in place supplemental measures, which typically would include things like encryption and separation of the data from the encryption key. One inference is that because of the Executive Order 14086 and the Attorney General's regulations, it's all fine, so you don't need supplemental measures. I always come back to the point that you still need, from a basic GDPR perspective, to have in play sufficient security measures because of your general duties as controller. That includes encryption. It includes the measures that had been classed as supplemental measures for the narrow purpose of international transfer. So I think we're in the same place in terms of the type of safeguards that need to be implemented, but there is a risk that they might slip off the table if the international transfer element is seen as done and dusted by the federal government measures.
It's the same sort of feeling that you're getting, Katie, from the other side of the Atlantic.
I completely agree with what you said, Malcolm. I think that's exactly the way to look at it. On this side of the Atlantic, I encounter many American clients who don't think that they should be subject to anything to do with GDPR. That's also an issue that I face all the time, which is I'm here. What does it matter? Like, how could I possibly be subject to GDPR? Why would I have to comply with that? So I think that's all part of the education of multinational corporations.
Absolutely.
American companies that do business in Europe. Yeah, I haven't heard the opposite expressed specifically, but as I said, I hear complaints about GDPR all the time.
So do we. You're not unique in that. So I'm feeling that maybe we need to revisit this subject in 3 or 4 months' time and see if anything's changed massively, and also to keep an eye on what good old Max is doing. So maybe I could invite you both back along with David to a sort of follow up in a couple of months' time. Is there anything else that you think we haven't covered today that you'd like to mention before we finish? David,
Oh, good, thanks.
welcome.
Just a couple of very quick drafting points, and it goes back to that onward transfer issue that I mentioned. There are a couple of amendments that will be needed to arrangements, depending on the way in which those transfers are set up. Clauses that, for example, require the recipient of an onward transfer to help the onward transferor to meet their obligations under the DPF principles. With a little bit of extra drafting that will need to go into some contracts. And there are a few other tweaks that do need to be made at quite a fine drafting level. But that's probably something to be that on a client by client basis to see where we need to do that.
Sure. Okay, great. And Katie, any final thoughts?
And to unmute, but no, I think I really welcome this new data privacy framework, because I think that having the privacy shield was great and companies really liked being able to certify and say that they were certified. And so I think it's good to have that back, because I think that was quite a good system. But I guess, yeah, I'm wary about how long it will last.
Interesting. Thank you all very much for your views and for guiding us through that today. I will invite you both all back in a couple of months' time. We'll arrange that. But thank you very much indeed for your information and input today. Thanks very much. Just to let everybody know, there will be a recording of this on our channel, which I'll make available later on, probably early part of next week. But thank you all very much indeed for coming along today.
Thank you.
Thank you.